Afternoon, everyone. Thank you for joining us on our webinar about the drafting of wills and powers of attorney. My name is Kristen Solis. I'm one of the mentor attorneys at the Dallas Volunteer Attorney Program. And if you're not familiar with DVAP, DVAP is a joint project with the Dallas Bar and Legal Aid of Northwest Texas. And our primary mission is to match low-income Dallas residents with private pro bono attorneys that will take on their civil legal cases for them. One of the most common cases that we get is requests for wills and powers of attorney. And in my opinion, that's probably one of the easiest ways to do pro bono is to give back. We have several of these cases that come in on a regular basis. We have a email referral system that goes out once or twice a month that has these cases listed. And if you're interested in taking a case, that you basically just reach out to us, say, I want to take such and such case, and we will happily get that to you. If you're not on our list, please contact Marcella, and she can certainly add you to our list. We do have the forms that you need, so you don't have to start from scratch, and we're there with mentoring and all sorts of things to help you along the way. Today, our presenter is Brandy Baxter Thompson. She is a board-certified probate attorney with the law firm of Land, Smith, and Salsalick. She is dedicated her practice to probate litigation involving states, trusts, and fiduciaries. She has been named a Texas Super Lawyer for 2007, 2018, 2019. In 2018, she was awarded the Ken Fuller Outstanding Mentor through DVAP. And in 2019, the probate section awarded her with the Nikki DiSceso Pro Bono Award. She has a BA from Austin College and her JD from Texas Wesleyan, which is now Texas A&M. She is super knowledgeable about estate planning, and she's one of my go-tos on anytime I have a question about what to do with these sort of things. So without further ado, I will turn it over to Brandy. Thank you.
Thank you, Kristen. I appreciate that, and I want to make sure you can hear me okay, right? So we are going to talk about basics of drafting wills and powers of attorney. And I believe I'm sharing the screen so everybody can see my the PowerPoint, and I believe it can be, if it hasn't already, emailed out to everybody so you can have this as a tool. And the way I drafted a lot of this is so that it can be a real easy, simple checklist that you can incorporate when you're talking with your client. So without further ado, I'll go ahead and tab on. Let's see here. So the first question, of course, is who is your client? And this is where we're going to get some of our ethics. I believe there's a 0.25 in ethics that we're going to receive if you attend the entire session. So the first thing is looking for elder exploitation and any undue influence. And if you have somebody that comes to you that is not the client, it can be, a friend, a family member, a caregiver, etc. But if somebody comes to you and says, I need to set up an appointment for my friend or my dad to redo their estate planning, one of the big red flags for me is when somebody calls and says, I need to get a power of attorney for my parent. That is something that you should dive into a little bit further. Make sure that the client, that this is something that they want. Obviously, you would never prepare a document without speaking with the client, would oversee the will signing, power of attorney signing, etc. in your office without any potential influencers available. Now, most of the time we have family and friends, that are just trying to be helpful, and the person, maybe they can't physically make it to the office themselves, and so they have somebody assisting them, and there's no issues whatsoever. But just, pay attention, listen to your gut, and if you do believe that there is some exploitation, potential undue influence going on, then you might want to report that to APS. That's something that we actually have a duty to do if we know that there is some wrongdoing going on. As far as married couples, that's a frequent representation of a husband and wife, spouses, and it's much more beneficial for them to be represented by one attorney. It's a cost savings, of course, and if their goals and are aligned, then it's easier to have one attorney prepare everything. However, you should have a conversation with the clients that if any kind of a conflict arises, that you can no longer represent them. And, a common conflict, if one does arise, is, one person coming back to you after you've had a joint discussion and wanting to make changes. You cannot, of course, take direction from one client without the other client knowing what's going on. The other thing I think that is important to have a discussion with them about is making sure that their goals are aligned and that there are no differences in what they want as far as the end goal. If they can't reach an agreement and they want, to do things very differently, then that may give rise to needing to have them each be represented by somebody else. Excuse me. I'll talk about documentation and things that you need to collect, but obviously with married couples, you want to ask them if there are any prenups, are there any partition agreements, do they have any prior marriages, etc. We deal a lot with blended families, and there's different considerations with blended families than there are with a long-standing marriage that they have 2 children together and those are their only children. So these are just different gathering points of information. So I love the New York Times cartoons, and I incorporate them a lot in my presentations. And this one I thought was pretty cute. It's a little less amusing when you hear your kids calling it the death tax. And I wanted to put this in here just as a signal to you that we're not going to be talking about estates that are obviously going to have to pay estate tax or have to file 706s. We've got a very high threshold for that, with $11.5 million being the exemption today. Will be rolled back at the end of 2025 if no further legislation extends it beyond that time frame. But what we're going to be discussing today is the basics. I think the basics and the things that we're going to talk about are going to apply regardless of the size of the estate. However, when you get into an estate that is taxable, then you're going to need to make sure that you have counsel that is familiar with the tax tax devices that can be utilized in those plannings. So these are the 3 major points that I'm going to talk about as far as with respect to will preparation, gathering information from the client, various points of discussion that you need to dive through with the client, and then of course just the technicalities and formalities of making the will and some things that have to be in the will. So the first point is going to be gathering information about their family. And one of the things I think about is, what does testamentary capacity mean? Well, in order for somebody to have testamentary capacity, they have to know the natural objects of their bounty. And so, especially when we're dealing with elderly clients, going through this fact gathering process with them is going to allow you to notice if there are any deficiencies, if there are any issues. If they don't know who their family is, then that's obviously a serious issue, and you might need to consider, not representing them or, talking to somebody about them getting some help. This is where you can also get into different issues related to, estranged children, estranged grandchildren. So who are they married? Do they have any children? We want to know if there are any minors. Is there anybody with special needs? Do they have any stepchildren or adopted children that they want to include in their planning or exclude? The same information needs to be gathered with respect to their grandchildren. So if they do have any minors or special needs beneficiaries, we need to dive a little bit more into that. Are there any special needs trusts that have been established by them or somebody else? I always like to include dates of birth for children. It's especially if they're minors, of course, but it's a very easy signal to the court or to an attorney later on once they've passed as to whether they are going to be dealing with any minors, and referencing any special needs as well, because they don't want to be leaving specific bequests to these people. It's going to end up requiring guardianship if they're a minor, and if there's a special needs individual, we don't want to disqualify them from any kind of governmental benefits by virtue of leaving them a substantial sum directly. They also, you might want to talk about, contingent trust in the actual will in the event that a minor receives a gift, or special need, if the executor determines that there's somebody that needs to have a trust versus giving it to them outright, they can make that determination, and you have provisions in the will for that. Gifts to classes. I've seen wills where they say, I want to leave everything to my nieces and nephews, but then they don't identify who those people are. You absolutely want to know who they are. You want to get their full names. Again, I think dates of birth are very helpful, as well as the city and state, especially if you have a class that's outside the immediate family. If this person does this will and then lives another 30 years, and then you are left with trying to gather all of this information, and it can be cumbersome and time consuming. But if you have this in the will, it's going to make whoever's dealing with it at that point job a lot easier. Another consideration is, do they want to leave anything to any charities? Not just charities, of course, but maybe they have a college or a university that they want to leave some money to, or to fund a scholarship, etc. So you want to make sure that you gather that specific information. Estranged children and grandchildren, it seems like this would be pretty obvious that they would give you all of their children, but I've actually had a situation where we got to the will signing, and the lady mentioned that she had a son that she'd never mentioned to me before. And so we had to stop what we were doing and include them, make provisions in the will for that person to say that they were estranged and that they would not be receiving. But you don't want to omit anybody that is estranged, because that person could then come back and say, well, they don't know who their family is. They didn't identify me as a child. So, and just know too, I do a lot of litigation in this area. And so that's kind of the context in which I look through some of these things, which I think is helpful as far as making sure that your client's wishes are carried out, and that, that they, have a sound plan in place. Of course, we have to know what their assets are. We need to know very specific information as to real property. A lot of people will just have, their own home, and that's enough. And or some people will have property that's outside of their home, or they'll have property in another state. If they do have real property that's outside of Texas, then they need to look at potentially having that put into a trust, because a trust is going to allow them to avoid probate in that other state. You may have a client that just says, I've got just regular furniture furnishings, there's nothing super valuable, but then you want to make sure, do they have any collections of any kind that might be valuable? Are there any specific things in, as I'll mention, a safe deposit box? And the reason you want to get some of these details is if these are the most common items that will be, given as a specific bequest. We want to identify any cash and securities, and if there's any interest in a privately held entity. So with respect to real property, I want to look at a deed. If it's, make sure that we've got the right ownership, confirming that ownership. You want to see if there's any co-ownership, because that obviously would complicate things somewhat if, how is their interest held? Is it an undivided interest? Is it partitioned, et cetera? Obviously, real property covers oil and gas royalties and mineral rights. A lot of clients in Texas will have some, that are here in Texas, but then but I've also run into a lot of situations where they have mineral interests in Oklahoma or Louisiana, a lot of times that they've inherited. And that's good information to have, because obviously that is outside of Texas. It's something that they're going to have to address through a probate in that state, and they may want to consider some other sort of mechanism so that they don't have to go through the process of probating in multiple states. And then also you want to have a discussion about homestead rights. I'll talk about this a little bit later, but particularly if you've got a partition agreement or a premarital agreement that may address giving up homestead rights, but make sure that they understand, if it's a separate property of one spouse. If it's the homestead, then that surviving spouse is going to have the right to live in that property for the rest of their life. And discuss the complexities with them of leaving a home that to another family member, maybe their children, when their surviving spouse is going to have a homestead right in that property. That can create a lot of conflicts, and but you want to make sure that they understand that if they're making a decision to leave it that way, that they are leaving that kind of complexity for their spouse to address. Already mentioned about tangible personal property being a common specific bequest, and that's why we need to get some detailed information. Accounts such as retirement accounts and brokerage accounts and bank accounts. Another point is life insurance. We want to make sure that we know where those items are, how much are in these accounts, and do they have any beneficiary designations? And if they do, that needs to comport with the way that we address things in the will. And I typically have a spiel that I give to each of the clients that I'm working with to explain to them the difference between probate assets and non-probate assets. And I just, let them know that everything we own can be put into one of those two categories. And typically, I think of non-probate assets as being related to some sort of a contract. There's a trust instrument, there's a beneficiary designation document, POD, et cetera, that allows them to leave that asset to somebody outside of the will. And it's particularly important when they want to have a will leave everything to one person, or a substantial share to a person, or even equally between their children. But if they don't have it set up that way with their non-probate assets, they may not be accomplishing the goals that they need, that they're wanting to accomplish. And so you need to be a counselor and discuss with them how all of these things work together to get their end game. And a lot of times that does start with, who do you want to leave your assets to? How do you want this to be divided? And then looking at the assets, making sure that everything works together. You want to ask about safe deposit boxes. I've entered safe deposit boxes that have absolutely nothing in them. I've gone into some that have thousands of dollars in cash. You want to make sure that you address that with the client, and make sure you know what's in the box. There may be some sort of a note that they want to leave with the documents to whomever is going to handle their affairs once they're gone. Also, who has the keys? Is there anybody else that can enter the box besides themselves? And I do discuss the idea of not putting their will in the safe box, because it can be very cumbersome to gain entry, especially if they're the only one with the key and they're the only one with the right to get into it. Just a side note, I'm involved in a matter right now where it's literally taking months to get into a safe deposit box. We know that there's a will there, but the bank is really balking at letting anybody gain entry. And this was, pre-COVID. So, there's, show cause orders that are having to be issued, et cetera. So, depending on the circumstances, it could be a safe place to put it, but it could also be a very difficult place to retrieve it from. Privately held entities, a lot of people will have an interest, in a family limited partnership or an LLC. maybe they've set it up themselves and it's where they hold their oil and gas interest, or they've inherited, some interest from a family member, from their parents, etc. There's a lot of information that needs to be gathered with respect to these entities, the formation documents. You want to identify the owners. You want to make sure that there aren't any restrictions with respect to how they, decide to pass these interests on. And I usually check the Secretary of State's website just to get another point of information to confirm the name of the name of the entity. Is it still, ongoing? Are there any issues that just, red flags that come up for me? And a lot of times too, you might want to gather some tax returns, both for the entity and for your client, just to confirm things. Because, a lot of times, people will have an idea of what things are and how much they own and what the interest is, but you always want to confirm it with documentation. Things change, they may not understand how they've changed, etc. So those are absolutely things you want to make sure you have before you start drafting anything. So obviously, once you know what they own, you want to know who do they want to leave it to. We've identified their family. That should be front and center at the very beginning of the will. That's how I usually put it in my wills. And then we now want to say, okay, who's gonna receive these various gifts? And of course, we've got family and charities, and then also a lot of people want to make provisions for their pets. I've done more than one will where we've had a trust set aside for enough money to go into it to take care of the pet for what they anticipate the life of the pet to be. Another just little funny to come in here, everything I have, son, I have because your grandfather left it to me. I see now that was a bad thing. So he's being prepared to get it disinherited, it sounds like. So other information to gather, of course, trusts. If your client is the settlor of any trust, if they have a revocable living trust, you want to look at that and discuss with them, if they need to make any changes to the trust. If they've got a pour over will and everything is going to go into that trust, and maybe the changes need to be made to that document versus their will. If they are the beneficiary of any trust, you want to know that. They may have a power of appointment. They may have some other interest that, needs to be taken into account with respect to their own planning. And then you want to ask them to provide you with copies, of course, of those documents. They may or may not have them. Sometimes they do, sometimes they don't, but you definitely want to have those documents. You want to read through them and make sure you understand exactly what your client's interest is. The other thing you might want to ask about is if there's any tax returns. And of course, looking at your own client's tax return, if you obtain that from them, it would have any K-1s if they're receiving any interest from other trusts. I've mentioned premarital and partition agreements. Obviously, that's something that you need to have a copy of and to take a look at. If in the context, I know this is basics, but just to keep this in mind, in the context of a premarital and partition agreement, if they're wanting to do these things, they need to both have their own attorney. We've had a lot of planners will incorporate a partition agreement for tax purposes, but if it's done in such a way that it addresses contemplation of divorce, you really want to make sure that they have somebody else, that they each have their own attorney advising them. So companion animals, we love our animals. We want to make sure they're taken care of. You want to get a lot of information from the client about, ages, types of animals. Do they have any health considerations? They may have somebody in mind that they think would be great to take care of the pets. Make sure that they are also comfortable with leaving money to that person to use for that pet's care. Another option to kind of bolster maybe a trust is to talk to their vet about putting a retainer, if you will, to cover any future medical expenses, their annual checkups, if they've got a specific kind of medication that they're on, potentially leaving enough money to cover that for a specific, a certain amount of time. If they do decide to set up some sort of a trust, talk to them about who's going to receive those assets once the pet passes. Do they want to leave it to a charity, or do they want it to leave it to the caregiver? Obviously, if they want to leave it to a charity, we want to make sure that you have the specific information about that charity identified so that it's clear. A friend of mine that represents Operation Kindness and SPCA on occasion has had to go to battle with different entities over, does this go to the ASPCA or does it go to the SPCA? Those are different organizations, and you want to make sure your client understands that what they want is actually going to happen, and get the specific information for that entity. Of course, in creating a will, we need to talk to them about executor. If there's going to be a contingent trust, who was that trustee? If they, have any specific bequests, making sure that they are articulated with enough specificity so that the executor knows what to do. And then covering the contingent disposition. If everybody's gone, when you pass, who do you ultimately want it to go to? So for executors, I always ask the client to give me at least 2 alternates. You don't want to just name one person as the executor. They may be deceased, they may be incapacitated, or they may simply not want to do it. And with that in mind, I generally ask them, please talk to these people that you are naming as an executor and make sure that they're willing to do it. They may not be willing to do it now. So, they need to find somebody else to assist them. Typically I want to know, where do they live? How old is this person? What do they do for a living if they're retired? If this person has no financial experience or, is not very sophisticated at all, is that somebody they really want to handle their estate if it's a complicated estate? If they want to appoint their aunt and their aunt's, 75 years old, they may want to think about having somebody that's younger, that is going to be sure to survive them. If they want co-executors, and a lot of times clients will come to you and they'll say, well, I want my 2 kids to be co-executors. And, that's fine if that's what they want. I think it's our duty to make sure that we explain to them all of the pros and the cons of that. And in going through all the information we've gathered thus far, you're going to pick up on, well, maybe they won't get along, or, they've always had a bad relationship, or, something that's going to clue you into, maybe co-executors is not really a good idea. But again, if ultimately what they want is what you're going to put in the document, but I think if you advise them ahead of time, it gives them some things to think about. Compensation, a lot of times people don't want to have any compensation provided for in the will if it's their children, which is, somewhat understandable. But I do, as somebody that served as an administrator in a state, I always explain to them, this is not a simple job. It's a lot of work. It may take them away from their own job. So just make sure that they think through, whether they want to include any kind of compensation. And if they do, how is that going to be calculated? If they just provide for reasonable compensation, explain to them, reasonable under the estates code, I believe, is a 5 in and 5 out. And what does that look like? If they may want to put a dollar, hourly figure and have that person keep track of their time. I think also reasonable would be if the person does keep track of their time and they, seek to have their rate paid at the rate that the county in which they're residing would approve, then that's considered reasonable. But they may have something else completely different in mind, but it's something that you want to talk through with them. Distributions of the tangible personal property, if there aren't going to be any specific bequests and it's just going to all equally go between a few different people, I always like to include non-pro rata distributions and make sure they understand what that means, that we don't have to sell everything to divide it, that we can, have some sort of system. having clients come up with a very specific system that they wanted the executor to utilize in order to make the division. But you also want to talk to them about, you know, what if they can't agree, the kids can't agree? Can we give the executor the authority to make the final decision, or do you want it sold? I mean, there's got to be some sort of a backup so that the executor is not left holding all of these assets and the children just can't make any kind of determination as to how they want them divided. If you've got a contingent trust, and you obviously need to have a trustee, and just kind of talk to them about, this is somebody that's going to be managing money. They're going to be a fiduciary. You want to make sure that the person that they are appointing is going to be, you know, sophisticated enough to deal with it, and someone that they trust to manage the assets and to make good decisions about the distributions and how much and when, etc. Again, compensation is something that needs to be discussed. You know, is there anybody that they would not want to have serve as trustee, and put that language in there? I've numerous occasions have had a parent that if they want to leave it to their son, and if the son's deceased, then it goes to the grandchild, and the grandchild's a minor, and so we definitely are going to have a contingent trust if something happens in the near future. They don't want the ex-spouse of their son to be the trustee, and so that's something to talk through with them and make sure that you address and put in the document if that is the case. And then discuss whether they want to have a bond put in place. Most people do not include bonds for individuals. I think if it's a substantial amount of money, they need to really strongly consider having a bond put in place in case something is not done appropriately with the money. And if they don't have anybody that they trust with to manage this kind of money, if it's a substantial amount, you know, talk to them about a corporate fiduciary, a corporate trustee that can manage the money and make those decisions. One other thing that I do like to talk to clients about is, you know, if they are wanting to appoint a family member, let's say an aunt or an uncle or somebody, is, you know, do you want to put that person in the role of managing money for another family member? It can become very awkward, and, you know, can kind of disintegrate that relationship. Instead, they may want to have this neutral third party corporate trustee put in place. Of course, you have to evaluate whether that even makes sense financially, because if it's not over a certain amount of money, then you know, the corporate trustee is probably not going to take it on. And so I usually give my clients a few different names of corporate trustees and tell them, you know, give them a call, talk to them, see who you like the best. And, you know, because there's a lot of really good corporate trustees out there, and whoever they, you know, feel comfortable with, then that's who we can name in there. But understanding that if it does, you know, when they pass, there's not enough money to fund that trust and have a corporate trustee in place, that there needs to be some sort of a provision, or even having it be decided by a court. Specific bequests. So, you know, most wills have a memorandum of personal property included, so that if the person decides that they want to have specific items go to somebody, you know, after they've written the will, signed the will, then they can just attach that to the back of the will. I always tell people, you know, you might even put, you know, a sticker behind a particular painting or whatever. And a lot of times it's good to just give those things away before you pass. If it's somebody that's elderly and they're downsizing and they want, you know, specific furniture items to go, then, you know, consider going ahead and making those gifts now versus waiting, you know, especially if it's something that you think people are going to fight over. But if it's a very specific item, I have had clients, you know, attach photos or take photos and say, these particular jewelry pieces are going to go to, you know, Susie or my granddaughter or whatever. I prefer to have that in the will, of course, but if they can't make a decision, you don't want to hold up having their will signed because they can't decide who's going to get their jewelry. Obviously, and I'll talk about this a little bit later, they can come back later and do a codicil that will kind of amend and put those specific things in place if they have made a decision. you know, again, with specific requests, if it's tangible items, you just want to be specific about what it is you're leaving. Of course, they can leave an entire class. If they want all their jewelry to go to their daughter and then want their gun collection to go to their son, that should be that's pretty easy to do. And if there is a specific class of items, then I usually prefer to refer to it as a class versus just listing every single thing, because they may acquire something different or sell something, you know, after they execute the will. Real property, of course, can be left specifically. If there's oil and gas interests related to that real property, I would be careful to address whether or not that specific request includes the real property, the underlying mineral rights. It should be, in most cases, presumed, but if it's a valuable oil and gas right, then you might want to specifically identify it as well. And of course, you know, contingent disposition, you know, ultimate disposition, if everybody has passed before that person, you know, it doesn't happen very often, but I have seen it happen. And if there's not any specific person or even class of persons or entity, charity, then you're going to have to do a determination of heirship, because a lot of the way wills are written, or I've seen, you know, older wills written, is they'll say that ultimately it'll be that whoever my heirs at law would be. And so that's not really that helpful. I think it just creates, again, having to do a determination of heirship. And if the person's, their children or grandchildren, or, you know, any of those people are gone, then it's going to be, you know, distant heirs, and it's going to be a complicated heirship. Again, I encourage people, you know, to identify specific people versus just having a class, of course, but sometimes they just don't know. And so that's what you have to put in there. If they don't have a specific charity, they might want to leave to a foundation. Again, you know, this is just an ultimate disposition. If they, you know, don't know who they want it to go to as far as a person, like distant relative, maybe they have some sort of charitable aim that they want to accomplish. So we've talked about gathering information about the family. We've talked about gathering information about assets and the specific information that we're going to need to include in the will. Now let's go through some of the requirements, you know, the statutory requirements to create a will, and some other drafting considerations. So this section, let's see, 251.001 defines who can execute a will. Of course, anybody over the age of 18 is or has been married and is a member of the armed forces can sign a will. They have to be of sound mind and at the time that the will is made. It has to be written, signed, and attested. So the will has to be in writing. You know, we don't have non-cupative wills anymore. So that's a requirement. Of course, it has to be signed by the testator. It has to be signed in the presence of the testator by the witnesses, and those witnesses must be over the age of 14. We do have holographic wills in Texas, which is a will that is wholly written in the handwriting of the testator. They, I think, are being utilized a lot more. I'm going to talk a little bit about COVID in the context of wills, but this is one thing that people I know have been utilizing in my office for people that are just really nervous about going to an office or, you know, to be with witnesses to sign a will. So in Texas, we allow for self-proved wills. The self-proving affidavit, you know, has been utilized for years and years and years. And it's, you know, obviously it's signed at the same time. You know, the will is signed by the testator and then the witnesses sign. And then we have the additional affidavit where everybody is attesting to the way that the will was just executed. And that is signed by the notary. And that allows the will to be self-proved. It makes for a very easy prove up. when the person passes away. There are no witnesses that are required to come to court. The only person that has to testify is the person that is seeking to probate the will, typically the person named as the executor. And so that makes for a very easy process. And quite frankly, in Texas, we probably have one of the simplest probate processes in the country. I tell people it doesn't matter what size of estate you have. You could have a $100 million estate or a $10,000 estate. It's the same exact process to probate the will. It's the same cost. It's the administration part that is obviously very different, but they all pay the same fee, same hearing, same oath, etc., and obtain the letters. And it's a very simple process. The 251.104 is where you can locate the actual form with the self-proving clause that we've just discussed. And again, the effect of that is that it obviates the need for witnesses to come into court and to testify. A few years ago, I guess several years ago now, this alternative to self-proving affidavit was enacted that allows for just a single, series. There's a paragraph that includes the language that a self-proving affidavit would typically have, that is then signed by the testator and then the witnesses and then the notary signs. So there's not the separate affidavit. This is just all done in one document. Actually, let me go back. One thing I want to talk about with this is we have some people in our office that still utilize the self-proving affidavits and others that have this alternative. And the one thing that I think some people still use this self-proving affidavit for is if for some reason the will is not signed properly, the will is not signed, actually just had a will that the person didn't sign, the testator did not sign the will, but they did sign the self-proving affidavit. So that separate self-proving affidavit, that signature can be used as the signature for the will to make sure that the will is valid and is admitted to probate. So I think some attorneys still like to use the self-proving affidavit and not use this alternative. It's a point of preference for you to decide and include in your documents and your forms. We now also have this new provision that allows for a designation of executor that says that the testator can designate a person that can make a decision about who can serve in the event that all of the named executors are deceased or disqualified or unable or unwilling. Of course, the person that's designated as the executor has to qualify as well. They can't have been convicted of a felony. They if they don't live in Texas, they need to have, appointment of resident agent on file, and have to be suitable. If there's just because they're designated, doesn't mean somebody can't come and challenge them as an unsuitable person, and the court can make that determination. But this is an interesting new device that we can utilize to try to avoid not, having somebody appointed or that's agreed upon by all of the family members, so that you can maintain an independent administration. And with that, this is language that, of course, that has to be in there in order for it to be an independent administration. The magic words. I also like to include, with respect to the inventory appraisement, is the language that says, or an affidavit in lieu as permitted under the Texas Estates Code, just so that it's very clear that that's an option. I know it's a statutory option, but I just have that language in there to be super safe. Points that you need to remember when you're drafting, these are all pretty evident, but, again, checklists are not a bad thing. And so just making sure that you have all of the immediate family members, even if they're not going to receive anything under the will, you want to make sure that they are included. If they are excluding somebody that is an immediate family member, or even if they're giving them a much smaller portion of the estate, they may want to include some sort of an explanation in the will, so that when the time comes and it's potentially challenged in a will contest, that there's some explanation, there's some logical explanation as to why that was done. I always include the dates of birth for their children, especially if they're minors or even just younger. Never include social security numbers. I don't see that very often anymore, but every once in a while you will see an older will that has social security numbers. And I mean, the court will redact those, and I don't know why you would need to have that in there, but make sure you don't have that in there, because that's, obviously very personal information. And again, defining children and grandchildren, at the end of the will, a lot of times people will put their definitions, or some people actually put them, at the very beginning, defining what classifies as a child. Does it include adopted children? Does it include stepchildren? Sometimes people develop such a close relationship with their stepchildren that they consider them their children, but maybe they've never formally adopted them and they want to include them. If you define them as such, then that will take care of that. Some other considerations here, again, some things you can maybe put on a checklist. We've already discussed, non-pro rata distributions, and how to resolve disputes over tangible personal property. You do want to make sure to include power of a sale. If that's not in the will, even in an independent administration, then you're going to have to go back to the court to get permission to sell. It can make it very complicated, and title companies a lot of times will not allow for the sale without having that language in the will. So you might want to make sure that that's in there. And also discuss incapacity. How is that determined? Who determines it with respect to both, the executor or the trustee that you've named, as well as the beneficiaries. Your client may have very healthy children and there's no issues, but what happens if somebody's in a car accident and has a traumatic brain injury, and they do become incapacitated at a later date, or you have a circumstance where they have children or grandchildren that have substance abuse problems. We've utilized that language to create a trust for somebody that is incapable of managing their financial affairs based on the determination of the trustee or the executor. And that can be a little bit dicey, but it also is, a way to make sure that something else is done with their money so that it's not given to them. If they're in treatment or they're on the streets, it just gives the executor or the trustee a little bit more, options as far as how to deal with that particular person. And codicils are it is a republication of the will when you have a codicil done. I don't do them very often, but they, again, as I mentioned, if there's specific little tweaks that they want to do and they just don't want to do an entirely new will, they want to just change the executors, or they want to add a specific bequest of a certain amount of money. Maybe they're now older and they have a caregiver, or somebody that's helped them and they want to leave them a little bit of money, or a housekeeper, etc. You see that on occasion as well. You can take care of that in a codicil, it's just a simpler thing. It does have to be executed in the same way that a will is. It has to have, the testator sign, 2 witnesses, and then a notary. And you can do, have a self-proving affidavit, or just have that alternative to self-proving affidavit. COVID-19. Never thought I would have to talk about something like this in this type of presentation, but here we are. And I think, the way that our office has dealt with this, and everybody has to look at this, what's best for them and their staff. But I think the best thing to do, no matter what, is just to develop some protocols as to how you're going to handle will signings if you are going to, in fact, do them. We have implemented where, we require the client to come in with a mask. All the staff wear a mask in the room. I usually greet them and escort them into the room, put them at the very end of we have a fairly large conference room. And then documents are kind of handed off by putting them on the table, and the other person pulls them off of the table. The staff, the 2 witnesses, come in and stand far enough away that there's, plenty of room so that everybody feels safe. And I just, I make sure that the client understands this is how this is going to happen, and make sure that they're comfortable with it. And, if they're not, then, I mentioned the holographic will, and I know one of the attorneys in our office has utilized that, where she's put together a will and sent it to him and said, you need to handwrite this all in your handwriting and sign it. And it doesn't require any witnesses. It's just, it's a very easy way to kind of get around this issue that we've got right now. Remote notaries, mobile and remote notary, in our office, we've decided not to do this. We found it to be a little bit cumbersome and expensive. I do know there are some lawyers that have done it, but when it comes to a will, it doesn't really help you because you have to still have those witnesses to sign and, for the exact testator to witness the witnesses signing in front of him. So, trusts, they don't have to be notarized or witnessed. So that's obviously a little bit outside the scope of what we're discussing today, but that's something that you might want to talk to your clients about. And powers of attorney, I guess we've got about 10 minutes left, and I'll just kind of run through this with you. I've always thought this was really funny. Well, I was bitten by a radioactive lawyer and ended up with the power of attorney. Love those cartoons. So what is a power of attorney? Power of attorney is a written instrument that appoints somebody to act as their agent. It creates a fiduciary relationship. It is a very, very powerful document that can allow somebody to take complete control of somebody's assets. And it's one of those things that, people throw it around as a simple document, but I, really explain to the client exactly, this is all the powers that they would have, and just make sure that they completely understand what it does, what it can do. And this is definitely a red flag when somebody other than the client calls you about a power of attorney. I will not even entertain preparing one unless I have spoken directly with the client and met with them and make sure that they are not being influenced in order to have this document prepared and name the person that's called me as the agent. So durable power of attorney is the most common. It doesn't lapse over the passage of time. You can, of course, create powers of attorney that have a specific purpose, that are expired a certain date. People that are engaged in some real estate transactions will sometimes give somebody power of attorney if they're going out of town and something might need to be signed while they're gone. A lot of that's not necessary in today's time because we've got, the DocuSign and these other things that allow for, distant signing. But the statutory form is found in 752.051. The agent or attorney, in fact, of course, acts on their behalf. I typically go through the process of saying, if this is somebody that would you be willing to give them access to all of your money right now? And if they are balk at that, then that's probably not the person that they need to have act as their agent. Talk to them about having an alternate agent. You want to make sure that there's multiple people in place so that if something happens to that person, again, this is another opportunity that they need to take to talk to the people that are going to be named as agents to make sure that they, are willing to take on this job. The form that we have now, you can, of course, indicate a single power, multiple powers. I think most of the documents I've prepared and had clients sign, the initial next to the O that gives all of the powers, but it can be tailored, and you can put specific transactions or otherwise expand or limit the powers farther into the document. Another discussion that you need to have is compensation and reimbursement. And I don't know why, but without every single person asks me, what does everybody else do? And I just tell them that, this is a very personal decision, and, you have to make a decision as to whether you want them to be compensated. But they need to understand if no choice is made, then reasonable compensation is what is permitted. What is reasonable? That's, there's a broad range of what's reasonable. And so they may want to decide, how do they define that? Do they want to give them an hourly rate, or, do they want to have it tied to 5 in and 5 out? It's just a discussion that needs to take place with them. There is a provision in the new form to give the agent authority to make gifts. And if this is you know, if they've never made gifts before, I typically have them, not, strike through this. If they have a history of making annual exclusion gifts to their children, their grandchildren, then they probably do want to continue this, especially in the event they become incapacitated at a later date and they want those gifts to continue. Springing power of attorney is power of attorney that comes to life when the person becomes incapacitated. A lot of people will want these because they don't want to give anybody any power until they don't have the authority, until they don't have the ability to do it themselves. However, you want to talk to them about what does that look like. You may have an issue with obtaining the proof that they are incapacitated sufficient for a bank to use the power of attorney or honor the power of attorney. One thing, if they do want to have a springing power of attorney, is to make sure any agents that are listed are also on the HIPAA release, because they may be in a conundrum where they're the agent under the power of attorney, but they don't have the authority to go talk to a doctor and get a letter that's required in order to have them, declared that they don't have the ability to manage their money anymore. So, make sure you cover that base with them. Some final thoughts. Ask a lot of questions. This is a process that is, takes a lot of time, getting to know the client, getting to know what their assets are, their family. It will lead to other questions. And I think the more information you have, the better you can advise them. You may have a very extensive conversation and end up with a very simple will that you're preparing for them. But it's really good to have those discussions and to really listen carefully to what they're saying and how they're saying it. We trust but verify. Confirm information through documentation. Make sure, not just because you think the person's going to be giving you bad information, but also just to make sure they understand things. And remember that we're counselors, and to be wary of those that are helpers, the family, son that is isolating mom and taking care of her, and but there's all these other children. You ask some questions about that, and you may have some red flags that come up. And then retaining copies. I don't keep originals anymore. I give those to the client, and I counsel them as to how to store them, and also to store other information. They may want to make sure they have a list of their doctors, of their accounts, who do they have life insurance with, just have a packet of information so that if something happened to them, somebody would be able to pick up a file and they would have access to all of this information and make their job a whole lot easier, especially if that person is not an immediate family member. If they're single and no children, and they've named a friend or a neighbor, somebody as the executor, then they want to make sure they have that packet of information, because they may not necessarily know where to look, and it just makes their job a lot easier. So thank you so much for the opportunity to speak with you today. I know we've got a lot of questions, and I think we've slated about 10 more minutes to try to answer those questions. And I'm going to look here. Let's see here. I'm going to start at the bottom. How do you revoke or cancel a POA? Must you inform your financial institutions? There's a specific form that you can sign that's a revocation of a power of attorney. Anytime I've done those, I record them in the county that the person lives and the county where the agent lives that you're revoking it from. Let's see here. When you draft wills, do you recommend that the documents contain a notation that the will was drafted by XY office attorney for possible information later? Yes, I always do. Elizabeth, yes, I have that at the end of my documents as to who's drafted it. And that is also in case that they can't find the original, they've got a copy, then they can come to me and I can confirm I don't have the original and maybe, help them with locating it if I've got something in my notes. Where should the will be stored? Should the person give a copy to the witness? I usually like to give a copy to whoever's named as the executor. And, it's a personal preference as to where it's stored. I personally like for people to put it in some sort of a storage in their home that allows, like a fireproof box in their home, because that's, you know, a lot of people are like, well, what if my house catches on fire? Well, if you've got a fireproof box, that's a good place to put it. If they're a couple, then a lot of times putting it in a safe box is probably not a big deal as long as they're both on the box. So is there a separate medical POA, or is agent authorized to make medical decisions under a regular POA? There is a separate medical power of attorney from a statutory durable power of attorney. And those agents a lot of times are the same, but they can also be very different because they may have a family member that they trust to make medical decisions, but is not good with finances. And so that's another point to discuss with them and make in deciding who they're going to appoint as their agents. I don't believe that a will can be executed over Zoom. It has to be in person. Mr. Klein asked a question about virtual remote notarization for a will. I don't believe that you can do that. I think that has to be done in person. Let's see. I'm not familiar with the ForTrust estate planning software. I mean, I think if you've got software and you want to utilize it as a starting point, that's fine, but you're probably going to have to spend more time going through that document unless there's a way to set up your own form. I just have my own forms. I have a form for men, I have a form for women, so that all of the pronouns are done properly, and I tweak every single will that I do, just about. To avoid signers touching a page that any other person has touched, do you see a problem having a separate page for each signer? In other words, the testator signs page 9, then page 10. I haven't, that's a good question. I'm not sure how that would work. And I mean, I guess as long as everybody's seeing it, I think one thing I meant to say is, any of these documents, if you're having your client do a holographic will, if they may want to come, or they do a power of attorney virtually. Now that one, of course, you can do a remote notarization for that. There's no witnesses required. I would come back after this is all over and have them redo their documents. I would just be really nervous about having a bank not honor a document, 3 years down the road that was done under these circumstances. Yes, a holographic codicil is valid if the will is not holographic. Yeah, that's a really, really good question. Access to intellectual property, patents, Facebook accounts, and other social media accounts. I think you can include language in the will that gives them access, but that's where having that packet of information comes in really helpful. And I joke with clients, but not joking, say, if you want to put all of your information in your computer, make sure you have the password to your computer available. Some people will have a spreadsheet that has every single account that they have with the password and login. That's a really good thing to have, but having language in the will that authorizes the executor to obtain that information. But then they have the issue of getting into it, so they've got to have that information as well. If the assets flow into a trust, does the will still need to be probated? I'm not sure if the assets flow into the trust through the will, then the will does have to be probated. If the assets flow into the trust by virtue of designations like an account, etc., then no. But that's a whole different topic of to probate or not to probate. I think at a minimum you could do a probate as a muniment of title. If you don't want to do an administration, there's some other options there. But can you speak to a Texas attorney ethically helping family members in other states create a will? Yeah, I mean, we have family in various states across the country, and I will talk to them with the caveat that everything I'm telling them is under Texas law and that it is not necessarily applicable. What I will typically try to do is just help them find somebody in their locality that can help them with those documents. Yes, you can draft a will if you will be identified as the executor, um, but not necessarily as the beneficiary. That I believe is prohibited. Um, you know, there's if you're the only child and you're a lawyer and you're preparing the will, you know, I'm not sure, but I think technically if you're the person drafting it, you can't name yourself as a beneficiary, and you probably shouldn't. If you choose to compensate the executor, will that be taxable to the executor as income? I believe that would be considered income to that person. So yes, it is a deduction to the estate. So if you're filing tax returns, that can be, and there's been a lot of income, they can use that as a deduction. So that would be definitely income to them. If the executor is also a beneficiary, can you just give them a bit more as a beneficiary to avoid them having to pay tax on income? I don't think it would avoid paying the tax, but it would essentially put more money in their pocket to pay the tax with. I think I've kind of addressed options for saving the documents. I always scan them. I keep a copy on our network, and then I email copies to the client so they have it electronically. I ask them if there's anyone they want me to send it to, and encourage them to also send it to people electronically so they have it that way as well. I do think it's best practice to name a trustee if you have minors. You know, there are some planners that have a contingent trust no matter what in their will in the event that somebody becomes later incapacitated. So, you know, it's something to discuss with the client. What issues or restrictions should be considered for wills drafted, signed, and registered in another state but probated in Texas? My understanding is if the will was executed in the formalities required by that state, then it is a proper will and can be admitted to probate in Texas. And it depends on the court as to what is going to be required to substantiate that. You may have to have an affidavit from the attorney that drafted it or somebody in that state. But that doesn't come up too often, but that's my understanding of what the basis is. What considerations should we think of when determining whether a client who comes for a will is a good candidate for testamentary or living trust? You know, I think trusts are almost a must when you have real estate outside of Texas. If you have a blended family and you want to leave assets to a spouse and then for their lifetime, and then upon their death, it goes to, you know, your children, that testator's children. Those are some considerations. It's, you know, very personal preference. One of the lawyers in my office, I think she always does a revocable trust with almost every plan that she does. Is there a way we can get a sample or template for a simple will and a sweetheart will with a POA? I believe the DVAP has some forms that they send out if you sign up to take on a pro bono case. I would encourage everybody to do that. There's also some really good CLE through the state bar that has some forms. So there's a basics, I believe it's a basics of estate planning that's held every February or March. And I don't think it's a live course. I think it's a recorded course, but there's always lots of great CLE with good forms there. What happens if someone has a will from a prior state but has since moved to Texas? I think I've already answered that. As long as it's properly prepared in that state, then you're not going to have any issues here. Are wills or powers of attorney an appropriate instrument for parents to designate or express preferences for custody of children in the event that both parents deceased? There's a specific form for that. You can do it in a will. I think if you're going to do it in a will, that's fine. I personally prefer to do it as a separate document, an appointment, a designation of guardian for themselves. There's that document, designation of guardian in the event a need arises, or to designate a guardian of the person and the estate, and they can be different people that they name in that document. You know, I think as far as updating and reviewing wills, there's a couple of different components of that. If there's a a lot of changes in the law that would affect most of your clients, then, you know, you might consider discussing with them or sending them something that says this is, you know, this is a change and this may affect you. Typically, I think a lot of lawyers will say, well, I'll review your documents to be updated and won't charge anything unless we actually prepare those documents. For the client, I always tell them, if you had any major change of circumstances, if you've inherited a lot of money, if you've gotten divorced, if you have children, or people that you've named as beneficiaries pass away, or there's just been some, you know, substantial changes in their circumstances, then they really need to have somebody look them over. I've had a client come in and we ended up not making any changes because it worked out, you know, that the change in their life really didn't affect their document. But that's typically a good reason to update the will.
All right, Brandy, I think we may be running out of time for today. If you want to wrap up a few of your thoughts and where anyone can contact you should they have further questions that did not get answered this afternoon.
Absolutely. Thanks, Maricel. And again, thank you for the opportunity to speak today. At the beginning of the PowerPoint presentation, I have my email and my direct dial. Anybody's welcome to send me an email or even call to go through any of this. I'm happy to help. I know we also, as Kristen mentioned, have a great program where if you do decide to take on a pro bono case, you will have a mentor that you can talk to about any issues that come up. And that's also a really great way to learn and to help out. And as they say at DVAP, billable hours for the soul. So thank you so much. I appreciate it.
Great. Thank you, everyone, for joining us this afternoon. I did provide the MCLE number in the chat box early on in the presentation. So if you still weren't able to get it, please feel free to send me an email. And again, thank you, Randy, for joining us. And thank you, everyone, for joining us this afternoon. Have a good rest of your day.
Bye-bye.